Start. Para. By this petition, petitioner challenges order dated 25 November 2020, passed by Chief Executive Officer of Slum Rehabilitation Authority under provisions of Section 13 (2) of the Maharashtra Slum Areas (Improvement, Clearance and Redevelopment) Act 1971 the Slum Act terminating his appointment to execute the subject slum rehabilitation scheme and granting liberty to respondent numbers 2 and 3 societies to appoint new developer of their choice for execution of the scheme. The order dated 25 November 2020 has been unsuccessfully challenged by petitioner before the Apex Grievance Redressal Committee (AGRC) which has dismissed the application number 105 of 2020 filed by petitioner by its judgment and order dated 31 May 2021, which is also subject matter of challenge in this petition. Para. Briefly stated, facts of the case are that land bearing CTS number 35 of village Juhu, Taluka Andheri, Mumbai Suburban District is owned by Maharashtra Housing and Area Development Authority (MHADA). The said plot of land is affected by slum structures. There is adjoining plot through which a nala runs which is owned by the Municipal Corporation for Greater Mumbai (MCGM). On MHADA land apparently there were 133 slum occupants, whereas on MCGM (Nala) land there were apparently 72 slum occupants. It appears that the structure occupiers on MHADA land have formed respondent number 2 society, whereas the structure occupiers on MCGM (Nala) land have formed respondent number 3, which is a proposed society. It appears that on 22 November 1999, members of respondent number 2 society executed individual agreements with petitioner giving their consent for development of MHADA land. Petitioner claims that he received more than 90% consent from such structure occupiers on MHADA land. A development agreement dated 9th May 2000 was executed by respondent number 2 society in petitioner's favor for implementation of the slum rehabilitation scheme SRS on MHADA land, and irrevocable power of attorney dated 9th May 2000 was also executed in favor of petitioner. Para. On 29th March 2002, MHADA issued Annexure 2 in respect of its land, in which out of the 133 structures, 121 structures and its occupiers were held eligible for implementation of SRS. The Slum Rehabilitation Authority (SRA) issued letter of intent (LOI) for construction of 180 tenements consisting of 19 commercial, 98 residential, 4 residential cum commercial, 54 project affected persons (PAP) and 5 amenity tenements. Supplementary Annexure 2 were issued on 24th February 2003 and 3rd May 2003 in respect of 20 additional occupants. Para. In the meantime, the 72 occupants on adjoining Nala land owned by MCGM formed a proposed society and adopted resolution appointing petitioner as a developer. Power of attorney dated 15th May 2002 and development agreement dated 20th May 2002 were executed by respondent number 3. Proposed society in favor of petitioner. MCGM issued Annexure 2 in respect of Nala land on 17th November 2003, in which out of 72 occupants, 52 were found eligible on account of addition of neighboring Nala land. SRA issued revised LOI to petitioner in respect of both the plots for construction of 184 tenements consisting of 141 rehab, 38 PAP and 5 amenity tenements. On 20th May 2004, SRA issued intimation of approval for construction of rehab building. On 7th June 2004, commencement certificate was issued for construction of rehab building initially at plinth level and which was extended from time to time, and full commencement certificate was issued by 7th January 2005. Stop.